Well, welcome everyone to the Safety Net podcast from the Virginia College of Emergency Physicians. I'm Jeff Kelly with VASUP Communications. Here today with me are two of our experts, one an emergency physician, Dr. Joran Sequeira. The other is a healthcare attorney, Nathan Kottkamp. Welcome to both of you to the podcast.
Thank you.
Thanks. Great to be here.
Absolutely. So the goal today is to give everyone an overview of some new medical guidelines and an algorithm for substitute decision-making for emergency care in the emergency department for patients who lack capacity. We'll get to that in a second, but just real quick here, a little bit of background on our two guests today. Dr. Sequeira is a VASUP board member. She's an emergency physician here in the Richmond region. She's a graduate of the New York Medical College and completed her emergency medicine residency at UVA. And at VASUP and across Virginia, she is very much a leading voice for those who lack capacity or are in need of mental health resources. She serves on a number of task forces statewide and has very much become a leading champion of helping create guidelines and getting people to the help they need. I'll tell you, I've gotten to know Dr. Sequeira over the last few years. I even shadowed her on shift a while back, and she's a physician with a very big heart. Nathan Kottkamp of Williams Mullen counsels hospitals and health systems on compliance with federal and state healthcare regulations, as well as their day-to-day operational issues. He's a nationally recognized authority on HIPAA and even holds his designation as a certified information privacy professional from the International Association of Privacy Professionals. He's long time been actively engaged in addressing complex public health issues. He's the founder and chair of the National Healthcare Decisions Day, which highlights the importance of advanced care planning. And he's done a lot of work with advanced directives, including serving on a task force of the Supreme Court of Virginia on mental health law reform. He holds his Juris Doctor from the University of Pittsburgh School of Law, where he also earned his Master of Arts degree in bioethics. So I want to get into this. For those who are following along at home, you can go to our website, vacep.org. We're also going to put a link in this podcast to the two documents that we're going to cover today, these new guidelines, as well as an algorithm. So to start, Dr. Sequeira, I think you should give us some background here on this project. You as an emergency physician who sees these issues day to day, talk to us about the need for these two documents that we're looking at right now from your perspective.
Sure. Thank you very much, Jeff, for having me on this podcast. So I'm on part of a work group where we're looking right now at medical TDO process. And what happened is we sent a survey out to our emergency physicians to get an idea of how they obtain medical TDOs, frustrations with that. And one thing that we found when we did the survey was that a lot of physicians, emergency physicians, almost a third of our survey results, didn't realize that there were different ways in order to obtain consent from patients. That getting a medical TDO is not the only pathway if a person lacks capacity, if a patient lacks capacity in terms of obtaining consent. I think a lot of physicians, while they know about advanced directives, don't realize how many other steps there are and other steps they can take in terms of getting consent.
Dr. Sequeira, can you clarify for us exactly who this algorithm is for so that there's no confusion?
Yep, of course. So this is for emergency medical care, as you said, in the ED. So specifically for those who have an acute medical condition rather than a psychiatric condition. So this is not in any way regarding a patient who needs acute psychiatric treatment or psychiatric admission. So this is for a patient who's coming in maybe and they lack capacity due to a psychiatric reason, such as paranoia, but they could also be having dementia, hepatic encephalopathy, other reasons for lacking capacity, but they need acute medical care, such as might need fluids for insulin for DKA or something like that.
And I think that's a good place for Nathan to come in with his legal eye, right? Obviously, you said there's a legal process here to getting patients the treatment they need if they lack capacity. Nathan, can you talk to us a little bit about the legal ramifications of informed consent and help us tee up the need for these substitute decision-making documents?
Absolutely. Just an inherent part of the delivery of healthcare in the United States and Virginia in particular, is that patients have a right to make their own decisions about their healthcare. And this comes into play in the concept of informed consent, so that where a patient is able to think about, digest, and proceed with a particular medical plan, they have that right. And that's why we have informed consent forms and all sorts of other mechanisms to engage patients throughout the process. There are inherently situations where that's not possible. The key one, and the one that we're talking about here, is emergency situations. Sometimes emergency situations where there is somebody that could make decisions because that patient can't make decisions on their own, and others where that doesn't exist. So first and foremost, it's not set forth in statute, but is recognized by courts. There is an emergency exception to informed consent as a whole. If the situation is dire, the question is, I'll just say, do we operate on a patient? We can't track down anyone to give consent, but the patient's going to die if we don't. Yeah, you proceed with the surgery. And consent is implied in a situation like that. In many cases, though, the situation is an emergency, but it is not so dire that you need to rush right into the OR. You have the time and you have the ability to find out if there is a way to respect that patient's right to have informed decisions made on their behalf. The way that breaks down is twofold. One is we look to see if they have an advance directive, which is a living will or a directive that identifies someone to make a decision maker. And we'll talk about those in just a second. The other is when that kind of documentation does not exist, and what we do and the default rules that we follow there. I'm going to start with that, though, because the reality is only about 25% of all patients, all people, all adults have an advance directive. So the overwhelming majority of the time, you're going to be dealing without a document, and you're trying to figure out, what do we do with this patient? Well, the law sets forth a very strict ordering of who the decision makers are. It starts with a legal guardian, someone that is specifically appointed by a court. Luckily, there aren't that many people that have a guardian, and when they do, you usually know about it. The next in order is the individual spouse. And then following that, and this is where things get complicated, everyone in each one of these tiers, if there are multiples, they all have equal decision-making authority. So it's adult children, it's parents if there are no adult children, then it's siblings, then it's any other blood relatives. So you can see those can lead to a lot of conflict. But I will also say that in an emergency situation, if it's the one child of the patient that brings in the patient in an emergency and you can't track down the other sibling, that's okay. You can proceed without having that other conversation because, again, we're sort of relying on that emergency rule. The moment the other child comes out of the woodwork and comes to the hospital, then yes, sure, you need to engage them both. But again, it's sort of a rule of reason, and there's not a specific set of requirements. There's no hoops you have to jump through on that reasonableness thing. If you got somebody you can make a decision, you do it. If you can reasonably get somebody on the phone, you absolutely should try. But if time doesn't allow, you proceed. There is also a mechanism in Virginia for making decisions by someone who's not a family member. So this is, a friend or the beloved neighbor who brings in somebody. There are limitations on that. And if you're ever in that situation, you're going to need to involve your ethics committee. So it's really not a true emergency option, but I put that out there because it is something that does come into play quite often.
So a patient comes into the emergency department and you evaluate them. When you are talking to them, you realize that, you realize that they might not have the insight in determining next steps of their care, such as getting lab work or treatment. So let's just say, for example, I have a patient who comes in who has not taken his medications his diabetes medicines in a while. So he's acutely psychotic, paranoid, and because of that and his condition, he's not been taking his diabetes meds. He's now nauseous, he's vomiting, his vital signs are terrible, he looks dehydrated. I'm worried this patient might be in something called DKA, diabetes ketoacidosis. So at this point, I want to get, I want to get an IV in him, fluids, insulin. And so at this point, I have to figure out, okay, well, he can't make, and he's refusing. He's, saying, I don't want this. Then it's like, what do I do?
One of the things I'll point out is that one of the reasons that we're in this situation and where things get tricky is the patient who lacks decision-making capacity, but has retained the ability to speak. And they speak in a way that is contrary to the obvious best interests of that person. So you could have someone who is suffering from one of the conditions that was just mentioned, but is still able to articulate things like, keep your hands off me, I want to go home, there's nothing wrong with me. And objectively, we as providers and onlookers know that that cannot possibly be consistent with their true wishes. And so what we try to do in a scenario like that is see if we can find indications of what that patient would want. Bear in mind, of course, we're talking about emergency situations. So keep in mind that like to get a guardian appointed for somebody takes days, if not weeks, in the court system. So you're not going to have the days or weeks. So that's where we then rely upon the emergency exception for informed consent. And what you should be doing, obviously, either you as the provider or others on the team should be documenting as you go along the steps that you've taken to try to identify the family, try to make phone calls, send text messages. 3 hours has gone by, we haven't gotten a response, we absolutely have to go to the OR right now. Just document what you got, and that's the way to proceed. But otherwise, if we can find a person, or we find instructions from the patient, in all cases, we want, to the degree that we possibly can, to follow that set of instructions.
And it seems like to me, Dr. Sequeira, one of the reasons we needed this was the time and sometimes inconvenience of getting a court or magistrate in for that TDO. In terms of timing for this, I mean, this could be maybe potentially much faster if what we're having to do is get a family member on the line, get that level of consent. Do you have any idea of how long some of these more alternative substitute routes might take?
I think one thing that's been really helpful is realizing that advanced directive, that there's a phone number that that we have on the bottom of this algorithm. It's also realizing that while, as Nathan mentioned, there's only a small percentage of our population that actually has an advanced directive. You'd be surprised that it's not just older adults, but a lot of patients with mental health also have advanced directives. So that's just a phone call away. So we do try to speak with family members, and that's, if we're able to reach them, that's not as time intensive or labor intensive at all. But I want to make sure that, everybody understands, like, if I need to take the time to make the right decision, I'll take the time. I want to make sure, I don't want to rush anything either, and do it the right way, as long as it's what the patient would want.
Sure. And Jeff, can I chime in here for just a second? That there are scenarios that I've seen in which emergency physicians have lost an opportunity to identify that person, to get an advanced directive. So somebody comes into the emergency room and they are suffering from whatever their condition is, and they are, they're in pain, but they're lucid, they're talking, and all of a sudden it reaches that critical point where they've lost consciousness and we can't get them back. One of the things that we would hope that emergency physicians do very early, and obviously you got to pay attention to the medical crisis, but part of the medical crisis is, what are we going to do if it gets worse? So one of the first things either the nurse or the physician should be looking at the chart, looking at the intake material, and if it doesn't identify an advanced directive or decision maker, get it immediately, because you never know when that patient's going to bleed out and lose consciousness. You never know if they're going to throw a clot and all of a sudden they can't articulate anything more because they've had a stroke. So there's a role to play even for physicians in what is technically advanced care planning, even if it's happening at the moment.
Wow. So I want to talk more about where people get stuck. A lot of people know, okay, advanced directive, if you've got a court-appointed guardian, but a lot of people don't know, okay, if you don't have those things and the person's objecting, what do I do? What are my next steps?
Well, first of all, you got to remain calm. That's the first thing I want to say. These are really scary situations because this is immediately when litigation starts to flash in the minds of
Yes.
providers. But what I don't want folks to lose sight of is the fact that those same rules on emergency exception for informed consent are going to apply in a situation like this. So Virginia has mechanisms for sort of overriding an objection, but those processes are going to take way longer than the duration of an emergency. So it's good to know that they're there. I strongly recommend that if you're ever dealing with an objection situation, that one of the things that happens is you trigger the ethics committee at the facility. In the meantime, when you're dealing with that patient, I think that the right answers are that you go back to what do you know that you're authorized to do? You might as well go ahead and do that. Use other mechanisms to try and get the process rolling. So you might be dealing with a request for medical TDO or some other mechanism. But what do you do in the meantime? You treat them to the best you can, consistent with the standard of care. You do what you can to help that patient, because the alternative is a dead patient, a patient who walks out, any of these other options. So, if I'm choosing a lawsuit to defend, I'd rather get a client who is dealing with some sort of battery than a wrongful death. Okay, so that's a piece of it, and then the other piece of it is um, the liability risk is real. I wish it weren't the case in a situation like this, but where it is real and where you're dealing with an objection, you need to really focus in on documentation. You have to imagine that horrible scenario where you are on the witness stand and the other side is saying, why in the world did you go ahead and treat in this scenario? Make sure that your documentation in the medical record answers that question. If it answers that question, you are almost certainly going to be fine. But it's when you go ahead, you do it, and you don't explain how or why you got to that place, that's when you leave yourself vulnerable.
The last question I have for you all is, what's next with this? Are we going to go back to the legislation? Should I get any changes made? Obviously we're going to be distributing this out to emergency physicians. Can you all give us some insight as to what's next?
I can point to one thing at least.
Okay.
There is a movement around the country. I don't know where it is in Virginia specifically, but I can guarantee you that it's going to be coming to enable the appointment of a decision maker without having to jump through the advanced directive hoops in the hospital with a clinician. If a patient were to voice their decision maker choice and it's observed by the physician and a nurse, why shouldn't that have the full authority of a piece of paper? I mean, we do all sorts of other things that we direct orally in healthcare to our physicians, but we don't have that mechanism. It's not prohibited, but there's also no safety net for that either. So there is a national movement. I've been trying to play a role in that. So I'd love to see that come to Virginia, so that when that patient comes in, without having to grab a piece of paper, you can just say, hey, I see you don't have an advance directive and we don't know who your decision maker is. Who's it going to be? And in the matter of 10 seconds, the physician can write that down and boom, we have an authorized decision maker. It would be tremendously more helpful than what we have today.
Sure. Dr. Sequeira, any final thoughts before we let you all go?
The one thing we heard from a lot of emergency physicians is the support we need in the department to help with patients who don't have capacity. And while I can determine a patient lacks capacity, go ahead and treat them according to the standard of care based on emergency medical condition, or even with a statutory agent, or even with a medical TDO in my hand. The issue is, how do I do that when a patient's trying to leave and I'm trying to keep them there? So we've had a lot of workplace violence issues with nurses, doctors getting spit at, punched at, kicked at. It's a real problem because the patient lacks capacity. So it's not their fault. They're not understanding what they're doing necessarily. And so the support we need from whether it's law enforcement or hospital security, we need something. And so that is what our hopeful next step is. Sometimes people will only act if it's a medical TDO versus it being an emergency medical condition. I've tried that before, unfortunately. And I've tried to say this person needs this for an emergency medical condition. We need to keep them in the room. Otherwise they will hurt somebody else or pass out in the street and have a cardiac arrest. And no support in terms of keeping that patient there. So that's kind of our next step is, I'm a tiny person, as are a lot of our nurses and even hospital security. So how do we keep the patient there?
Well, Nathan, Dr. Sequeira, I appreciate both of you for taking some time with us today to talk about these new guidelines, which again are available at vacep.org, as well as the notes on this very podcast. Thank you all for listening, and we'll see you on the next show.